Good evening. Welcome to Oconee County Board of Commissioners meeting. Today is Tuesday, April the 7th, 2026. After a moment of silence, we're going to ask Holly to lead us in the pledge. Please stand. Thank you.
It's to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
First item is to approve the agenda.
Make a motion to approve the agenda as submitted.
Second.
A motion and second. All in favor?
Aye.
Motion carries. Our next item is statements and remarks from citizens. This is for anything not on tonight's agenda.
Thank you, Mr. Chairman. I'm Lee Becker, 1050 Scott Terrace. And I wanted to take this opportunity to announce and to invite you to a candidate forum that Katie Vickery and I have organized for April 21. And I'm really pleased to say that the new owners of the Oconee Enterprise are going to be a co-sponsor. It'll be held at the Community Center in Oconee Veterans Park. And it's for the contested races for Senate District 46, both Democratic and Republican, and House District 120. Of the 7 candidates, we have firm commitments from 5. We're hoping the other 2 will send a representative. These are the only 2 candidates who aren't from Oconee and Clark County. So if you have the ability to nudge them to come and participate or send a representative, I'd appreciate it if you did that. But the invitation is to all of you, but anybody in the audience as well. We hope to have a good turnout. So again, it's 5:30 to 8 p.m., Oconee Veterans Park Community Center. And for the audience that might not know, it's 3500A Hog Mountain Road. And we're looking forward to having people have a chance to ask questions directly of the candidates. There'll be 3 different panels, so there will not be overlap between the races, but rather there'll be a panel for 46 Democrats, 46 Republicans, and the Republicans for the 120th. Thank you very much.
Thank you. Any other citizen comments? Any statements or remarks from commissioners? Early voting starts on April the 27th and runs through May 15th. And that'll be from 8 to 5 here in this building. Saturdays on May 2nd and May 9th, voting will be from 9 a.m. to 5 p.m. Also, there's a public information open house on the 16th, and that will run from 5 to 7 p.m. This is related to the State Route 15 bypass of Watkinsville. There is a GDOT website that's up now that has the 3 different alternative routes. So you're welcome to take a look at those. You can leave comments online, or you can show up here at the meeting on the 16th to let your voice be heard. Next time is approval of the minutes. This is for March 3rd, March 26th, and March 31st.
Make a motion to approve March 3rd, 26th, and 31st as submitted.
Second. Motion is second. All in favor?
Aye.
Motion carries. The next item is a proclamation recognizing April 2026 as Safe Digging Month in Oconee County. We're going to ask Chuck Horton to read that proclamation.
Oconee County Safe Digging Month. Whereas thousands of times each year, the underground infrastructure in Georgia is damaged by those who do not have underground lines located prior to digging, resulting in service interruption, environmental damage, and threat to public safety. And whereas in 2005, the Federal Communications Commission designated 811 to provide contractors and homeowners a simple number to contact utility operators to request the location of underground lines at the intended dig site. And whereas the Athens-Clarke Oconee Utility Coordinating Committee, a stakeholder-driven organization dedicated to the prevention of damage to underground utilities in Georgia, promotes the National 811 notification system and Georgia 811 in an effort to reduce these damages. And whereas damage prevention is a shared responsibility, and by using safe digging practices, the contractors and homeowners in Oconee County can save time and money and help keep our infrastructure safe and connected by using safe digging practices. Now therefore be it resolved that the Board of Commissioners of Oconee County, Georgia does hereby proclaim April 2026 as Oconee County Safe Digging Month and encourages contractors and homeowners throughout Oconee County to always contact 811 before digging, because safe digging is no accident. Signed, Chairman John Daniel, 3/31/2026.
Thank you. Jody. Okay. We'll go out front and present that to Jody. Now we'll move on to our hearings and actions on zoning matters. Our first is a variance P 25-0309. This is a request to allow more than 5 lots to access a private access drive on 3.34 acres located at 3810 Malcolm Bridge Estates Ridge Residential.
Thank you, Mr. Chairman, Commissioners. Again, this is variance P 25-0309. Abrar, Ambreen, Ansari, applicants and owner. This is parcel B 03W023, currently zoned R1 in the suburban neighborhood character area. Again, the request is applicant requesting a variance to UDC section 101207 to increase the maximum allowed lots accessing a private access drive easement from 5 to 6. This is the recorded plat showing the proposed access lot onto the private access drive. A slightly larger version showing the proposed location of the house, proposed barn, and the location of the required septic area. These are photos submitted by the applicant, architectural renderings. And staff recommends conditional approval with our 1 standard condition. Number 2, the owner shall submit a revised final plat at their expense to remove the 1-foot no access easement to the Whistling Creek Crossing common access easement. The revised final plat shall show all updated flood insurance rate map information according to the latest FEMA firm panels. And number 3, the applicant shall submit a site plan prepared by a design professional along with the building permit application for all proposed structures on the site. Building permit shall not be issued prior to the recording of the revised final plat with the clerk of courts. Thank you.
Now we'll hear from the owner.
Good evening. Thank you for this opportunity to present this variance application. So I'll do my best to be brief. Building sort of the house that we've been planning for years has been kind of a dream for my wife and I. This property uniquely has 2 creeks that intersect. It forms a triangular shape, and the widest portion, the base of that triangle, is that drive, the private access drive, which is currently allowed 5 driveways. So this is sort of forcing the driveway to be built through a cul-de-sac, which is a narrowed kind of pinch point. And there is a large oak tree that's right in the way of that, which would require removal. And so in keeping with the geometry of the lot, and also to sort of minimize the cut and fill and only improve the character of the neighborhood, we have no intentions of trying to take away or create something atypical or odd. We only wish to improve and maintain sort of the character of the area, allowing access through that wide section at the base of that lot would just kind of keeps with that natural geometry of the lot.
Thank you very much. Does anyone else wish to speak for this variance? Does anyone wish to speak against? With that, we'll close public comments. Any questions from commissioners? We'll entertain a motion.
Mr. Chairman, I make a motion to approve variance P 25-0309 for Abar and Ambreen. Sorry, request to allow more than 5 lots to access a private access drive, 3.34 acres, 3810 Malcolm Estates Ridge Residential.
We have a motion and a second to approve variance request P 25-0309 with 3 conditions. Any discussion? All in favor?
Aye.
Motion carries. We'll move on to an appeal of administrative decision on P 26-0069 Deferred Tax LLC. This is appeal of an administrative decision made by the administrative official of Oconee County regarding an applicant's eligibility for review. This is for 6.84 acres Oconee Connector.
Thank you, Mr. Chairman, Commissioners. Again, this is a Deferred Tax LLC, Jeff Deloach, applicant, attorney, property owners, Deferred Tax LLC, located at Oconee Connector, parcel C01045B. Current zoning is OIP, established by rezoning P 25-0223 by the Board of Commissioners on January 6, 2026. The issue summary: the applicant is appealing a decision of the planning director that a preliminary site plan P 25-0281 for 2 buildings with a total of 26,000 square feet of retail space with a restaurant was not reviewed by the Development Review Committee, while an active rezoning case was pending for the property. The application was not processed not processed because of Oconee County UDC Section 1214, which states, upon initiation of submission of a valid application for rezoning or special use approval on a property, no permit shall be issued, nor shall any actions be undertaken on the property that may be affected by the outcome of such application. This section of the UDC was in effect at the time the county initiated rezoning was filed on October 7th, 2025. The findings in history: the county initiated a rezoning on the property October 7th, 2025, parcels C01045B and C01045, a total of 33.65 acres. Preliminary site plan P 25-0281 was submitted for review on November 23rd, 2025, while the county initiated rezoning was being processed. A completeness review was issued on December 1st, 2025. As stated, this property is currently undergoing a rezoning, and no processes can be undergone until a decision has been reached on the rezoning. While the zoning application was pending, no action was taken. The Board of Commissioners adopted the zoning resolution P 25-0223 that amended the zoning of parcel C01045B to OIP. The applicant requested a status update of the preliminary site plan application on February 4th, 2026 via email from Mr. Deloach. And on February 13th, 2026, the plan director responded via email and indicated, under the current zoning, the property reflected on the site plan is zoned OIP. The retail uses shown on the submitted site development plan are not permitted uses under that zoning. If the owner submits a site development plan that shows a use consistent with the current zoning, the department will review it. On March 6, 2026, the applicant submitted the appeal of administrative decision indicating that staff has not followed proper procedure in reviewing a preliminary site plan while a zoning action was under consideration by the Board of Commissioners. The analysis: the applicant indicates that Oconee County UDC Section 1214 halted the Development Committee review of a preliminary site plan filed while a zoning action was pending. Oconee County UDC Section 1214 temporary suspension of permitting during zoning change was applied and in effect during the rezoning process. Oconee County UDC Section 1205 initiation of zoning change authorizes the Board of Commissioners to initiate a rezoning application. Once the rezoning was completed on January 7th, 2024, the property was rezoned from B2 to OIP. The applicant claims that the preliminary site plan should be considered under the previous zoning district of B2 established by a rezoning case number 8340 on October 3rd, 1988, and not the current OIP zoning district. Oconee County UDC Section 20508 and Table 2.1 indicates a retail use is not allowed in the OIP zone. Thus, the plan director indicated a revised site plan was required for review prior to the review by all departments for the preliminary site plan P 25-0281. Thank you.
Jeff?
Thank you, Mr. Chairman. Ken, you can come on up.
Thank you, Mr. Chairman. Again, Jeff Deloach here on behalf of the appellant in this appeal. There's case documentation that Mr. Herring and his staff have submitted, so I'm going to do my best, obviously, not to go through that. That is the record that you all are reviewing for this appeal. So my intention is to avoid duplication of that record. However, I do have to make sure that you have everything we think is appropriate for you to consider for that. And for that reason, I am going to call Mr. Ken Bell to testify, to put in just a few documents that we will do very quickly as contemplated by Section 1307 of the UDC. I did speak with Mr. Haygood. He indicated that I should swear in Mr. Bell, so I'll do that, and we'll go through this pretty quickly. So, Mr. Bell, if you'll step to the microphone, please. Please raise your right hand. Do you swear from the testimony you'll give in this matter will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
All right, if you will, just state your name while everybody knows you. Just state your name for this record.
Kenneth A. Bell.
All right, Mr. Bell, how were you involved in the original approval or application on this matter?
As the owner and landscape architect at Bell and Company, we were asked to prepare the documents that were submitted.
Okay, and I'm going to hand you what I've marked as Exhibit A1. Do you recognize this as the application that you submitted with the documents that were also electronically submitted with the application for preliminary site review?
Yes.
All right. I'm going to hand you what I've marked as Exhibit A2. Please take a look at that. Do you recognize that as the email that you received on November 23rd, indicating that your application had been successfully submitted?
Yes.
Okay. I'm going to hand you what I marked as Exhibit A3. Do you recognize this as an email that you received on December 1st, 2025, indicating that an application completeness review had been completed on the preliminary site plan, and then with a link that you could click to review that?
Yes.
Okay. And is the attachment to that first page a printout that you printed from the link that was available from the Oconee County system?
Yes.
Okay. I'm going to hand you what I've marked as Exhibit A4. Do you recognize this? Let me ask you this. What is this?
This is a printout of a list of the documents that we uploaded to the portal that related to the request for the preliminary plan.
Okay.
Preliminary site plan approval.
And is the first thing there an indication that on December 11th, 2025, you added a traffic impact study?
That's correct.
Okay. And is this a document that you printed and provided to me?
Yes.
Okay. I hand you what's been marked as Exhibit A5. Do you recognize this as what you printed on January 30th, 2026, showing the status of the application for preliminary site approval as reflected in the Oconee County electronic records?
Yes.
Thank you, Mr. Bell. I don't have any further questions. You are the county is entitled to cross-examine you if anybody has any questions. Mr. Haygood indicates that there are none, so thank you very much. You may be seated. Mr. Chair, if I may approach you, I'll just hand these.
Yes, sir. Thanks.
Actually, I do have one more. I should have done this at the same time. Mr. Chair, I've communicated with Mr. Haygood and Mr. Herring, who provided an accurate copy of Article 12 of your ordinance, and I'd like to submit that as part of the record. Mr. Haygood, do you have any questions about what I've put in? Okay, thank you. And I will try to be efficient and certainly respect your time here. But this is an important matter that I want to make sure I have the opportunity to explain from the appellant's perspective. This notice of appeal is submitted in accordance with section 1306.01 of the UDC. I'm not going to repeat what Mr. Herring, I think, very accurately described as factual background. There's not any dispute, I think, about any of those facts that Mr. Herring recited for you. The decision being appealed is the opinion or determination, I should say, provided by Mr. Herring via email on February 13th, 2026, which again, I think was accurately described by him. And to be specific, Mr. Herring's interpretation acknowledges that the site development plan was submitted by the applicant on November 23rd, 2025, and these dates are really important under the law. But the decision states that because a potential rezoning was initiated by this board, was pending at the time the application was submitted, the site plans proposed must now comply with the new OIP zoning, which was not passed until January 6th of 2026. And Mr. Herring states that the retail uses shown on the plan submitted with the application in November are not permitted uses under the new OIP zoning. Again, the date that the application for preliminary site approval was submitted is not in dispute. It's November 23rd, 2025. And it's undisputed that the subject property had a B2 zoning designation at the time the application for preliminary site plan approval was submitted. That B2 zoning designation had existed on this property since October 4th, 1988. That's over 37 years. The zoning of this property was changed 44 days after the application for the site plan approval was submitted. Again, as reflected in the introduction by Mr. Herring, on October 7th, 2025, the Board of Commissioners discussed and voted to initiate a modification of the zoning on the subject property and neighboring property owned by my client. While this board-initiated rezoning did not go before the Planning Commission, it was required to be properly advertised, to have a public hearing, and to comply with Georgia's zoning procedures law. Ultimately, you all did that, and the zoning hearing and vote occurred on January 6th, 2026, where the subject property was rezoned over the owner's objection. Now, I just went through some documents. On November 23rd, Mr. Bell received an email stating that the application completeness review had been completed, but that additional documentation was necessary before being accepted for full review. Clicked on the link. We provided the document that he got to, and the only review comment says this property is currently undergoing a rezoning. No new processes can be undergone until a decision has been reached on the zoning. So at that point in time, I reached out to counsel for Oconee County, asking for an explanation of the position. And Thomas Mitchell, on behalf of Oconee County, responded and explained that it was the county's position that Section 1214 of the UDC suspended permitting during a zoning change, and that the then pending board-initiated zoning precluded consideration of the preliminary site plan that was submitted for approval. I responded on behalf of the applicant, explained our position that Section 1214 should not be applied to preclude the review, and requested that Oconee County continue its review of the application. Those emails are in the record for y'all to see. The legal arguments are discussed in those emails. Despite this request, Oconee County continued to suspend its review, and nothing changed in the online portal regarding the application. Now, after the rezoning in January, having not received any status update, that's when I reached out to counsel for Oconee County on February 4th, inquiring about the status of the application, and received the response from Mr. Herring that we've been talking about on February 13th, 2026, which is the decision being appealed. So now I get to the part of the legal argument that's really important. And that is, the bottom line is the interpretation of the planning director and the application of the UDC is legally flawed and violates Georgia law. This is important. It is a well-settled principle that once a proper application is filed under zoning regulations then in effect, the developer acquires a vested, constitutionally protected right that cannot be impaired by subsequent zoning changes. That right attaches at the moment of filing and includes not merely the possibility of future approval, but the right to have the application processed and decided under the laws that existed at the time of submission. Now here, again, you all know, application was submitted November 23rd. B2 zoning existed at that time. The submission is the vesting event under Georgia law. So the right to be considered under B2 zoning occurred at the time of the submission on November 23rd. This principle is directly established by the Georgia Supreme Court, which has said, and I quote, "A landowner has a right enforceable by mandamus to be issued a building permit in accordance with zoning regulations as such regulations exist at the time a proper application for building permit is submitted to the proper authority." That's WMM Properties v. Cobb County, 255, Georgia, 436. That's a 1986 Supreme Court case. Now, appellants' vested rights here are constitutional in nature. They arise independently of any local ordinance, and they cannot be undone by any administrative fiat or a pending legislative action, such as the pending board-initiated rezoning in this case. Now, based upon the plain reading of the text of Section 1214 of the UDC, it really doesn't even try to alter the constitutional rights that are granted at the time an application is submitted. It says, upon initiation or submission of a valid application for rezoning or special use approval, no permit shall be issued, nor shall any actions be undertaken on the property that may be affected by the outcome of such application. It doesn't actually say that it doesn't actually say that the subsequent rezoning becomes the rezoning that must be applied to the application. That's not what it says. It just says you got to hit pause. Now, we argue that even that, in this case, should not have been applied because the rezoning could not affect the outcome of this application. But either way, Section 1214 does not purport to eliminate, after the fact, the county's duty to process and consider a properly submitted application under the zoning laws in effect when the application was filed. It only limits the issuance of a permit if the action may be affected by the rezoning application. Now, in this case, the outcome of the board-initiated zoning couldn't affect it. I've already explained that. Therefore, Section 1214 does not apply. And then to the extent that it has been relied upon, it's been errantly relied upon. And the bottom line is Section 1214 cannot change Georgia law that requires an application be considered based upon the zoning designation at the time of submission. Now, additionally, the UDC is subordinate legislation. That means local ordinances must be consistent with the Georgia Constitution and with state law, and they are invalid if they are in conflict. The Supreme Court has repeatedly struck down local ordinances that attempt to override state-level constitutional mandates or statutory mandates. You've got Forsyth County v. Georgia Transmission Corporation. That's a 2006 Supreme Court case, 280 Georgia 664, that sets that out. Section 1214 is no different. To the extent that that section seeks to extinguish or suspend a constitutional right, it's unenforceable. Now, the planning, I'm going to go to something that maybe is a little something I think y'all have dealt with before and talk about because it's exactly the same thing. The planning director's interpretation of Section 1214 has the legal effect of allowing this board to stop potential development plans on any property by merely initiating a proposed rezoning of the property. By doing so, you would permit all permit review would be stopped, and then the property owner would have to comply with whatever new zoning that may be put in place, even though a valid permit application was submitted prior to rezoning, and that is not Georgia law. The interpretation of this, the way this is interpreted, basically results in any board-initiated rezoning to serve as a moratorium on development of that property. I think that's moratorium is something y'all have dealt with before, and Georgia has well-established law on moratorium. What is required to have a valid moratorium? First, a moratorium that functions as an interim zoning ordinance must comply with the zoning procedures law. That includes a public hearing and providing proper public notice before adopting policies and procedures governing the zoning decision. Failure to comply with these procedures renders the moratorium invalid. Georgia Supreme Court, Tilley Properties v. Bartow County, 261, Georgia 153. Additionally, a moratorium must be a reasonable exercise of the county's police power justified by a legitimate public interest. It must address the specific and immediate need for the moratorium, maintaining the status quo while revising zoning codes and adopting a comprehensive land use plan. The Georgia Supreme Court has explained these requirements numerous times. DeKalb County v. Townsend Associates is one of those where sewer tap moratorium was found invalid. Now, in Cannon v. Clayton County, 255, Georgia 663, this is a 1985 case, still very good law. The Georgia Supreme Court addressed a moratorium, and what it said is directly on point in this case. So I'm going to read the quote. We have held that in this state, when land is zoned for a particular use, an applicant properly applies for authorization to use the land for that particular use, he is entitled to have such authorization issued. An applicant must thereafter comply with all reasonable conditions and requirements imposed upon the use of the land. And if he fails to do so, the governing authority can withhold building permits and occupancy permits to enforce compliance with these regulations and conditions subsequent. But a governing authority cannot deny or postpone requested authorization to use land for a permitted use and then defeat the applicant's right by thereafter rezoning the land. That's exactly what this application of Section 1214 of UDC did. Exactly what the Georgia Supreme Court said you can't do. The court cited a previous case decided on that issue, and one of the several previous cases, actually, in one of those cases explains that if this happens, if a property is subsequently rezoned, then the use to which the owner is entitled to based upon the timely application before the rezoning becomes a non-conforming use that can be continued. That's what should happen here. You rezoned it, but they're entitled to have this review, and that becomes a non-conforming use. Additionally, in Georgia, a moratorium cannot be applied arbitrarily or capriciously, and it must be uniformly enforced and not target specific individuals or projects unfairly. A moratorium that targets a specific property owner, such as the applicant in this case, violates the Equal Protection Clause of the Georgia Constitution. And so that, for that very reason, interpreting Section 1214 of the UDC in this way, making any board-initiated rezoning process effectively a moratorium preventing permits from issuing on a particular property violates Georgia's equal protection standards. So, in summary, the applicant's vested rights to have the application for preliminary site plan approval to be reviewed under the zoning that existed on November 23rd, 2025, when the application was submitted. That was B2 zoning that had existed for 37 years. The planning director's interpretation of Section 1214 of the UDC results in that ordinance being invalid under Georgia law. As a result, our request is simple. We request that the Board of Commissioners reverse the interpretation and decision of the planning director and determine that the application for preliminary site plan approval, that was application PS 250281, should be reviewed under the B2 zoning designation existing on the property at the time of the application. I know this is not something you all deal with all the time, and I know I've talked fast, but I hope that when you look at the record and you hear the law that is well established by Georgia, you will genuinely consider this appeal. I will certainly answer any questions if you have them and appreciate the time you've given me. Thank you.
We do have a little bit of time for public comment, and this can only be related to the appeal of the administrative decision and not to the underlying rezones that are in question as well. So, any public comment? Hearing none, we'll close public comments. And you have anything, Daniel, to add? We ready for a motion on the appeal of the administrative decision for P26-0069?
I'll make a motion to uphold the planning director's decision.
Second.
We have a motion and a second to uphold the appeal of administrative decision on P26-0069. Any discussion? All in favor?
Aye.
Any opposed? Motion carries. We'll move on to our text amendments, the Oconee County Unified Development Code, Articles 2, 3, 6, 11, and 12.
Thank you, Mr. Chairman. Again, this is text amendments to Articles 2, 3, 6, 11, and 12 of the Unified Development Code. You have these in your application packets. Number one, amendment to allow private business schools and computer and management training and private technical and trade schools as uses allowed by right in the B1 and B2 zoning districts. This will change, have changes, revisions to principal use table 2.1, section 20509, B1 general business district, and section 20510D, B2 highway business district. Number two, amendment to change the use all other outpatient care centers to be allowed by right instead of special use permit in the OIP, B1, B2, and OBP zoning districts. You see those sections that will be changed for that one. Number three, amendment to allow for administrative review and approval of a 5-lot split minor subdivision in the R1 zoning district. This change will be in the R1 single family district, section 205 and table 2.1. Number four, amendment to change the uses of barbershops and beauty salons to be allowed by right instead of special use permit in OIP zoning districts and their associated section changes. Number five, amendment to correct a cross-reference on outdoor storage and clarify that in the B1 and B2 zones for construction contractors, builders, developers with outdoor storage, a special use permit is required to align with section 36201, outdoor storage in commercial zoning districts. And the associated sections that will be required to be changed. Number six, amendment to allow on-street parking within a public or private right-of-way with parallel spaces for CBU units. The parallel spaces shall have a wider pavement section outside of the travel lane with minimum width of 13 feet and a length of 26 feet with a pavement taper designed to be approved by Public Works. And those are the associated sections to be changed. Number seven, amendment to remove the restriction on maximum number of spaces allowed for larger vehicles in off-street parking lots. Number eight, amendment to exclude churches from the requirement that all parking be within 300 feet of an entrance. Number nine, amendment to correct a cross-reference section between sections 122109, 30604. Clarify that parking lot light poles are allowed to be 30 feet in height as indicated in section 30604. Number 10, amendment to remove the roof pitch design standard in B1 zoning districts. Number 11, amendment to allow data processing hosting related services only in industrial zoning districts with a special use permit. Number 12, amendment to allow churches and other places of worship neighborhood scale in the B1 and OBP zoning districts by right. Number 13, amendment to allow churches and other places of worship community scale in the OBP zoning district with a special use. Number 14, amendment to allow temporary event religious assemblies in the OBP zoning district with a special use permit. And number 15, amendment to revise the stormwater requirements to revise redevelopment standards from the stormwater ordinance to satisfy requirements for at least 20% of the site's impervious area. This will revise section 1113 applicability. And that is all. I'll be glad to answer any questions if you have any. Thank you.
Anybody have any questions on these text amendments? Do we have any public comment? With that, we'll entertain a motion on the text amendments.
Make a motion, we approve the text amendment as submitted.
Second.
A motion and a second to approve the text amendments for Articles 2, 3, 6, 11, and 12. Any discussion? All in favor?
Aye.
Motion carries. Next item is consider an appointment to the Oconee County Board of Tax Assessors.
Mr. Chairman, the motion, we appoint Leif Hansford to the Board of Tax Assessors immediately to March 31st, 2028.
Second. A motion and second. Any discussion? All in favor?
Aye.
Thank you. Motion carries. We'll move on to our discussion and consider of a county-run EMS strategy. We had a town hall meeting held on March 26th. We also discussed this at our March 31st. We did have a strong turnout with relevant comments and questions during our town hall meeting. Regulatory oversight for EMS rests with the Georgia Department of Public Health. The department is led by Dr. Kathleen Toomey, and Dr. Toomey is appointed by Governor Brian Kemp. They handle licensing, compliance, and enforcement of statewide EMS standards, and also manage the Office of EMS and Trauma. And they also have the ultimate decision on ambulance zoning plan. The state is divided into 10 EMS regions. Oconee County is part of Region 10. It consists of the following counties: Barrow, Clark, Elbert, Greene, Jackson, Madison, Morgan, Oconee, Oglethorpe, and Walton. Each county is considered an EMS zone. The designated 911 zone provider for Oconee County is Trinity St. Mary's and Piedmont Athens Regional. Both hospitals provide EMS service to Oconee County, or did at one time to Oconee County via no charges for a hospital-based ambulance service. Together, both hospitals decided to end the hospital-based model for EMS for Clark and Oconee County. And in 2008, the hospitals contracted with National EMS to provide service to both counties. Contract provided National EMS a $400,000 annual supplement paid by the hospitals. Contract also created an oversight committee with representatives from each hospital, each county, and National EMS. The purpose of the committee was to periodically review and evaluate the performance of National EMS. The committee was empowered with authority and responsibility over the following as well: to investigate and respond to any and all complaints, inspections, or investigations arising in connection with National's provision of service under the agreement. Also to annually review National's billing rates as well as billing and collection effort and policies, and to review reports related to National's provision of services. In July of 2018, National EMS sells to Priority Ambulance, which is a portfolio company of Enhanced Equity Fund. In 2019, a legal opinion was issued stating that the Oversight Committee did fall under Georgia open meeting requirements. And based on HIPAA concerns, the committee did not meet after that opinion was issued. We've seen negative trends in priority response times. And while response times are not the only factor to consider, the trends do indicate some change in operation or performance. A national report for the entirety of 2024 shows 239 priority 1 response times over 12 minutes and 59 seconds. The national report for the first quarter of 2025 shows 112 priority 1 response times over 12 minutes and 59 seconds. We first started hearing concerns on billing and collection processes in September of 2024. Now, crazy numbers well outside the usual and customary charges for our region started popping up. Since the Oversight Committee stopped meeting, no outside review of quality assurance occurs on behalf of Oconee County. As we try to address concerns directly, senior management claims HIPAA and no further conversations occur. Our citizens deserve to have accountability outside a corporate structure. National has been pushing for a subsidy to double the subsidy paid by the counties and the hospitals without any change in the level of service. And as we have attempted to work through these challenges, two clear goals have come to the forefront. First, we must be the designated 911 zone provider for Oconee County, and we must have local control and oversight of EMS operations in Oconee County. The most favorable, economic, efficient, and with the most benefit to public welfare method to achieve these goals is to have a county-run EMS. So it's in my recommendation to the Board of Commissioners and the citizens of Oconee County to create a county-run EMS and become the designated 911 zone provider. Starting up the EMS structure, we'll talk about for a few minutes. Our startup focus will be 100% on 911 readiness, no non-emergency transports, standby, and dedicated truck assignments will be based on policies that support our 911 readiness. Use of medical billing company will be used. Oversight and accountability will rest right here with your Board of Commissioners. We'll have an EMS director. We'll have EMS supervisors, one per shift. They will operate a med unit. That unit will be staffed with an EMTA for the peak hour 7 days a week. We'll have a paramedic and EMTA staffed on 3 trucks, 24/7, 365. As we start up, we'll have 5 Type 1 ambulances, 3 operating 24/7. one 24/7 with a supervisor, and then one in reserve. As volumes dictate, supervisor will move to a quick response vehicle, and Med Unit 4 will be operating 24/7 with a paramedic and EMTA. We expect a unit hour utilization based on committed time to fall between 0.2 and 0.6, on an average on-task time falling between 1.5 and 2.0. 2.5 to 0.30 is the ideal for reliability and economic efficiency. The life of our trucks will run between 4 and 5 years. Trucks will be monitored for maintenance and operation costs as well as mileage. Boxes are also remountable onto new chassis when the chassis wear out. We'll have a similar life cycle management to what we do for the sheriff's office for frontline vehicles. Depending on the startup time, Med units will likely have to be at fire stations initially. We have property in Watkinsville and on Malcolm Bridge Road available for EMS stations. Vast majority of our medical calls are in Station 1 and Station 8 territory. The net cost to taxpayers of $1.9 million. We approached National initially for a subsidy to provide a similar setup, and we were quoted $2.4 million. Also calculated a subsidy based on Priority's recent bid submitted to Barrow County, which would indicate the cost would be $2.354 million. I'll be happy to answer any questions or comments from commissioners. Do we have any public comment on this item?
Tommy Malcolm, Northwest Woods. Just wanted to say thank y'all for having the town hall. I was able to see it from a distance, but I did have one question. Obviously, this has been well thought out, and I understand the historic nature of not only our volunteer fire department, but our EMS. And I was just wanting to, as we go forward with this, to see if there's any opportunity for, I'm just kind of thinking families, individuals, or corporate citizens, or maybe even other local governments within our county, as a way of saying thank you and appreciation for somehow donating to the cause as we go forward. I know other places have ways that they contribute. There might already be a system in place, but I think as we go forward, just to help offset those costs and to see if there might be some folks who, whether it's individuals or families or citizens or maybe even other local entities, saying, hey, we want to kind of contribute, and what would that look like? Thank you.
We'll take a check tonight, Tommy, so.
Say the same thing. If you know some, just tell them to come up and see our finance director. Be glad to take that check.
Yeah. We have a special revenue fund so that anybody can submit for that and designate it to the EMS, and they would go to that. Same for Parks and Rec or any other department. Happens a good bit. Any other public comment? I think we're ready for a motion on this item.
I'll make a motion to approve all that has been said.
I'll second.
We have a motion and second to move forward to county run EMS. Any discussion? All in favor?
Aye.
Any opposed? All right, motion carries. Our next item is discuss and consider approval of a contract to purchase ambulances. This goes along with our just completed vote. We have received a proposal provided by 10-8 Fire and Safety for a cooperative agreement with HGAC contract AEM 1023. This is for Type 1 CCL 150. It's 5 units on a 2026 Ford F-350 XLT chassis. Cost per unit is $224,800. So use of the cooperative purchasing contract is permitted under county purchasing policy and satisfies competitive bidding requirements. So the question for tonight, or the request is for tonight, is approve this contract for a total of $1.24 million, and this will be funded from SPLOST. Do we have any public comment on this item? We'll entertain a motion.
I make a motion, we approve the contract to purchase ambulances as submitted. Second.
We have a motion and second. Any discussion? All in favor?
Aye.
Thank you. Next item is discuss and consider approval of a contract to purchase ambulance equipment. This proposal has been submitted by Stryker Sales LLC per cooperative agreement through Sourcewell for various equipment required for effective operation of 5 ambulances. Total cost of $768,279.65. Use of this cooperative purchasing contract is permitted under county purchasing policies and satisfies competitive bidding requirements. So the request tonight is to approve the contract for $768,279.65, which will come from SPOS Capital or opioid funds. I have trouble getting that out. Sounds like I've been popping them, so. Do we have any public comment on this item? With that, we'll entertain a motion.
Make a motion to approve the purchase of ambulance equipment as presented.
Second.
Have a motion and second. Any discussion? All in favor?
Aye.
Any opposed? Motion carries. Does any commissioner wish any item to be removed from the consent agenda? Hearing none, we'll entertain a motion.
Make a motion, we approve the consent agenda as submitted.
Second.
We have a motion and second. All in favor?
Aye.
Motion carries. We have no need of executive session, so Commissioner Sacks,
Motion adjourned.
Second.
we are adjourned.